We have three distinguished colleagues who are joining us. Troy Paredes, who is a commissioner of the U.S. Securities and Exchange Commission from 2008 to 2013, having been appointed by President Bush and confirmed by the Senate, which is an excellent combination of things to have, having had both of those myself. He's now the head of capital markets and strategy at Norm AI, one of our sponsors, and lectures on regulation and policy at UPenn Law School. Secondly, we have Professor Dan Berkowitz, who is a commissioner of the CFTC from 2018 to 2021, and then general counsel of the SEC until 2022. He's a partner at Millennium Partners and he co-chaired the Dodd-Frank Reform Working Group at the CFTC, and earlier in his career, he was a senior staff lawyer at the Senate Permanent Subcommittee on Investigations. And then in the middle, we have the distinguished Professor Cary Coglianese of the University of Pennsylvania Law School, who is one of the eminences in regulatory law and administrative law, with a particular emphasis on empirical evaluation of alternative regulatory strategies. He runs the incredibly well-respected Penn Center on Regulation, something that we emulate a little bit here at the Regulatory Studies Center, and we welcome him coming down to speak to you all today. And so with that, I will turn it over to Commissioner Paredes.
So the plan here, and I've known Dan for a while, I've known Cary for a little bit longer, perhaps, than I've known Dan, so it's a real treat for me to have the chance to have a conversation with the two of them, and you got a brief intro to their bios. Among the three of us, I think what you have is a blend of folks who have academic background, folks from government, as well as other different roles in the private sector. So there's a variety of different vantage points to try to bring to bear and offer. And I think that a lot of what we're going to chat about is going to piggyback on what the professor had to say, as well as what Commissioner Johnson had to say. The framing is this: if you think about what the overall topic here today is, AI and regulation and different aspects of regulation. And as Commissioner Johnson mentioned, there are questions around how, let's just call it the private sector, the marketplace, how businesses use and deploy AI. There's also really interesting questions about the ways in which the government can develop, use, and deploy AI and how those things may intersect. And when you're thinking about that question, and you think particular about the aspect on regulation, you don't have to go very far to then start thinking about administrative agencies and how regulators, the regulatory bodies that make up the administrative state, do what they do as a matter of practice. And then if you take one more step, you realize, well, pretty quickly you're talking about administrative law, because the contours of administrative law have effect on how administrative agencies do what they do, how regulators situated within those agencies do what they do, and pretty soon how regulation becomes what it becomes in terms of substantive rules, administration of regulatory requirements, as well as the enforcement by the agencies of those requirements when they think there's been a violation. And so for me, what I think is particularly apt and timely about the conference and hearing from Dan and from Cary is not only the leaps and bounds, it seems like, geez, almost on a daily basis, maybe it is on a daily basis, in terms of the capabilities of AI and advanced AI systems and frontier. The frontier of what AI is capable of continues to be pushed out farther and farther. And again, the commissioner was talking about that, as well as Professor Dooling was talking about that. But what's also been going on is very significant changes across the administrative state. A lot of that coming out of not just perhaps the capabilities of AI, going back to one of the themes, but also what's going on when it comes to administrative law. And when you think about, as this title has by way of this panel has by way of the title, you think about the overturning of Chevron, a type of judicial deference to regulatory and agency decision-making with Loper-Bright. Another case that didn't get quite as much attention is Corner Post. You have Jarchese, for those who are focused on that and what the implications there are in terms of agencies' ability to bring cases administratively where they seek civil penalties. The finding was you got to comport with the Seventh Amendment right to jury trial. You think about the major questions doctrine. You think about delegation or non-delegation, or however you want to put it. You think about appointment and removal of administrative law judges. You think about the Administrative Procedure Act and all that that entails in terms of reasoned decision-making and can't act in an arbitrary and capricious manner. All that stuff's at play. And in some senses, in significant respects regarding the shifts, and perhaps the biggest shift that seems in the offing is the overturning of Humphrey's executor, which speaks directly to the independence, or we'll see how much independence on a go-forward basis when it comes to the independent agencies like the CFTC, like the SEC, like the FCC, like the FTC, and we can go on down the list. So the conversation today, I think among us, will be against the backdrop of all of those goings on, and that's a heck of a lot of goings on. So with that by way of tee up, and I may have missed something, so Dan and Cary can feel free to fill in any gaps. I'll start with you, Cary. Thoughts? what do you make of all that that's going on? And in particular, you've written extensively, and I would note you've been writing about the implications of AI from a regulatory perspective for a long time now. This is not a new thing for you. Your work from several years ago in terms of regulation by robots, which is really kind of early on anticipating the prospects of where things may be going, and again, what the speakers already have talked about. What's big picture? What's your take on what's going on?
Well, thanks, Troy, and thanks to the organizers for inviting me to be here. It's interesting that you say that I've been writing about this for a long time. It's been 8 years or so, and that is in AI terms an eternity, perhaps. Although I suppose, in a way, I've been writing about and working on issues related to IT, information technology, and the rulemaking process for nearly a quarter century now, starting with way back when e-rulemaking and the transfer of information to government websites and so forth. But clearly we are now in a different era. I think one thing to say, by the way, of foundation setting here is that there's a necessary level of generality that these conversations probably have to take in a setting like this. And that's both on the side of administrative law and on the side of AI. When I teach administrative law, I tell my students that the name of the class is a bit of a fraud because there is no such thing as a single body of administrative law. If you're at the SEC or the CFTC or the EPA or OSHA, administrative law may be governed by many general principles, may be affected by certain structural constitutional norms, but also is governed very intimately by those organic or substantive statutes, and it can vary from agency to agency. So that's one. On the one side, administrative law is really administrative laws. And when it comes to AI, I like to say that AI is not a technology. It is a suite of technologies. It's quite, incredibly diverse. So I think perhaps most of us have been most familiar with AI since OpenAI's ChatGPT entered the landscape back in, I think it was November of 2022 with version 3. And then 3 months, 4 months, or 5 months later, it came out with version 4. Interestingly enough, for anybody who's a lawyer in the room, that 6 month or so period of time from those two versions, the AI, that large language model performed on the uniform bar exam at initially the 10% level, big failure, to the 90th percentile, big, huge success, and passage rate is sort of humbling for us who train humans over a 3-year period of time to be lawyers. But nevertheless, that's only one type of AI, generative AI. And even with that, there's differences between ChatGPT and Google's Gemini and Anthropic's Claude. Okay. And then those are quite different than a lot of what might be thought of as more traditional AI models that are trained to perform more concrete specific tools, reading the cancer, detecting cancer on radiographs, for example. That's not something you do just with ChatGPT, but it is artificial intelligence tool too. And the same thing goes for the algorithms that are in the Waymo taxis that you might have driven in if you're ever in San Francisco, right? So there's a lot of heterogeneity, and I think that heterogeneity has important implications not only for noting that at the outset of a conversation like this, so we're not always talking past each other. But also, I think it has implications for how we think about public policy. If we're thinking about the rules of administrative law that should govern AI, well, maybe there's different rules for different types of models or different types of uses. Same thing is true when the government is overseeing private sector AI development and use. There may be need for different types of rules, different agencies, or more flexible strategies. I like to say, and I guess this is what I'll end my opening comments, when it comes to regulating AI, and I think this is true both whether we're thinking about its use in government or in the private sector as government is overseeing it, we can't think about constraints on AI using the metaphor of a guardrail. Often we hear that. People want to put guardrails around this technology. Well, guardrails, if you think about it, just at least metaphorically, those are really fixed, rigid. You put them at the sides of roads that are already well defined, and you know where they're going. But we don't know where all of these technologies are going to be able to put fixed guardrails in place. And if we did put fixed roadblocks on them, we could lose the benefits that can come from some of these technologies. So I like to say what we need to think about, drawing an analogy to another type of non-human intelligence, that is our pets, particularly dogs. If you take a dog for a walk, you're often required to have a leash on the dog. That's flexible. It allows the dog to meander, wander, take the path that the dog would like, much like we might want to have technology explore different paths, find new things. But there's always a human at the other end, able to rein it in, oversee it. And I think that's what we should be aiming for on, again, whether we're talking about AI being used by the government or AI in the private sector that government is overseeing.
Dan?
Thank you, Troy, and thanks for the conference. It's a pleasure to be here. I'm more of a user of AI than an expert in AI, but it's a fascinating subject, and I'll sort of talk about it in my first, what I have to say here, more on a higher level, like where are we going with all this? When I use AI now, I want to find me cases that say this or stand for this proposition. And it's just absolutely incredible research tool. And I can even ask it, how will the Supreme Court rule on this question or that question? And it does that really, really remarkably well. When I was general counsel at the agencies, the SEC and CFTC, the chair would always ask that question. If we take this approach, what's my chances in court? What are the probabilities I'm going to win with this interpretation versus that interpretation? And, you send lawyers to go down the chain. I call my deputy, and they would assign it to their team, and people would do the research and go to the library. And we moved, when I started out, it was books on the shelf. And then you get Lexis or Westlaw, and you can actually do it with an incredible database. You don't actually have to pull the books off. The AI can do that instantly. I mean, you don't have to send associates off to do these things. At least it looks to me pretty good. Now, maybe if somebody checks it or whatever it is, but it's really, really remarkable time saver. But ultimately, you advise the chairman, what's the probability? You could say, well, we think the court will do this or the court will do that, or here's the probability, here's the arguments. But what do they do with that? And Troy, you've been in the position as a commissioner. You get the lawyer saying, well, we think, here's the strong position, here's the weak position. You might go with the weak position for various other considerations. Litigation risk is only one decisional criteria that an executive makes. There may be political pressures to go one way, or you may that may be a very outdated, outmoded, legal perspective, and you want to change it, or you want to push it, or you don't want to take the blame for not doing something, you blame it on the court. So ultimately, that only is one factor into an executive decision. But the other point is, more generally, our whole system, our entire government, our constitutional system is not designed to be the most efficient. AI can really help certain parts be efficient, but if it were to we say, well, look, we've got this incredibly efficient decision-making process. Why do we really need 5 commissioners at a regulatory agency? AI can spit out the maximal approach with all the data better than any human being can be. Why do we need all this administrative inefficiency? It can instantaneously summarize the comments. You look at the Washington Post these days, you have to read through the comments to get a feel, and now AI summarizes it, and you just have to look at the AI summary of like the reader comments on the Post to get a feeling of what people think. So we can do all that. You can summarize the comments, and you can come up with some algorithmic, probably write a Federal Register notice pretty well too. And then you publish it, you take comments, and you never even have to meet with anybody or not, depending on whether you want to. But the whole administrative law process, the Administrative Procedure Act, people think of it as technically a very dry statute on how administrative agencies should do rulemakings or adjudication. You have to have a notice of rulemaking, give the notice of what you're going to do. You have to have comments for a certain period of time and respond to the comments, and there's a whole body of case law in what reasonable means and what arbitrary and capricious means, and then there's other cases about the boundaries of when Congress needs to be more clear than others. But the Administrative Procedure Act was really a compromise at the time of a bitter battle that's going on today. Troy, you mentioned Humphrey's executor. When the administrative agencies were created in the New Deal, to respond to the economic crisis that the country was in, the administrative agencies were created to have a body of experts, a bit insulated from politics, who could address the nation's problems that were getting much more complex at the time: securities law, maritime, labor. We were in the 20th century. It wasn't the 19th century. We were an agrarian society more. We had modern industrial problems. We wanted bodies of experts to address these. Well, so you set up bodies of experts, but they need to be politically accountable. And who do they report to? Do they report to the president? Are they independent from the president? What's their relationship to the Congress and the elected people? Are they accountable? So all those questions were swirling around. There were Supreme Court cases. There was a Humphrey's executor case. President Roosevelt finally appointed all members of the Supreme Court, and the Supreme Court, surprisingly or not, had a different view on many constitutional issues about whether the structure was legal or not. What could you delegate? Why is an agency rulemaking, why is that different from Congress making a law? So how can some agency other than the Congress make law when the Constitution says Congress makes the law? Well, the Supreme Court finally said it's okay as long as there's appropriate delegation and there has to be an intelligible principle. And then the question is, the members are removable by the president or not, which is now come back again. But it wasn't designed necessarily to be the most efficient system. There's checks and balances, and there's public input and public accountability. I can tell you there was a question earlier about whether if you get a ticket, you want somebody to complain to. A couple of things. When we did Dodd-Frank, I was at the CFTC when we were doing the Dodd-Frank legislation, the initial rulemaking at the CFTC. It's unbelievable. It's about 15 years ago by now. And I was general counsel of the CFTC at the time. A little bit louder. I was general counsel of the CFTC at the time. We were implementing the Dodd-Frank legislation through rulemaking. We had many, many rules pending. The industry thought we were just a blitz of rulemaking. And I would go out, the chair sent me out to give presentations to various groups that were affected by the legislation. I described the rulemaking agenda and what the substance of the rules were, and obviously, there were a lot of people very interested in that. As general counsel of the agency, people would say, well, what's the agency going to do? And why are you doing it this way? Why are you doing it that way? And really, all I could do was summarize the rule and say, well, if you've got a comment, please write in. I didn't have any authority to respond to comments or make any decisions about how the agency would respond. I would just go out and describe what we were doing and listen to basically a lot of really hostile comments from industry who hadn't been regulated before, and now they were being regulated by these new regulations to respond to the crisis. But it was absolutely, as I learned, I said, well, what's the point of me going out there? I can't respond to anything. I'm just sort of being a punching bag. But it really was the people who had an interest in and were seriously affected by what the government was doing really, really wanted the opportunity to tell that to a person, to tell that to somebody in the government and have them listen directly. They weren't just content just writing a letter in that might be read by a human being or might be read by AI. It wasn't AI at the time, but it really was very basic to people to come in, and it's actually one of the least known First Amendment rights in the Constitution. There's the right of freedom of the press, freedom of assembly, freedom of religion, and then there's also the right to petition the government for the redress of grievances. And that's a fundamental First Amendment right that people really, really want to exercise and be able to exercise. So having somebody in the government listen, you all know how frustrating it is if you got some consumer thing and you're trying to get through the hotline, the consumer hotline, and press 1 if this and press 2 if that, and nobody's picking up, and finally just like 0, I want to talk to somebody. But it's really fundamental that there be people in the government who listen, and that this is what this town is about. People come in, there's conferences, they meet with the agencies, they explain to the regulator, they want a human being to talk to. So anyway, efficiency isn't the only objective, and I think humans are absolutely critical part of the administrative process.
Just to pick up on that and marry it, Cary, to what you were saying, then I'm going to come to you with the question. You feel free to just react and whatever. You don't have to answer my questions, right? They're really more just prompts than anything else. Is you had made the point, Cary, that when you're teaching administrative law, you note that it's really a misnomer. It's administrative laws, plural, because there's all the variation, which I think is an astute observation. And in some of the experiences, Dan, you were recounting, what comes to mind is it's very contextual, right? And the context of different decisions are very different. Not just from Dodd-Frank, or you can pick your agency, you can pick your rule, regulation, you can pick your statute, you can pick the broader environment. So all that context matters. The combination of those things, and this was something that I hadn't fully appreciated when I went to the SEC. So before becoming a commissioner at the SEC, I was a law professor. So I was a professor of law at WashU, doing corporate law, securities law, and some other stuff. I had never taught administrative law. Didn't think about myself as being an administrative law scholar, and I still don't put myself on the same level as Cary when it comes to administrative law. But what I learned when I went to the commission is the SEC is as somebody who had written about the SEC was more from the perspective of substantive securities regulation. Some about how the agency does what it does, but it was more about substantive securities regulation. And just to your point about administrative law, singular versus plural, when you're thinking about the SEC or the CFTC, or again, we can go through the long laundry list of agencies, you talk about, Commodity Exchange Act or securities regulation or telecommunications law or what have you. But that itself is a bit of a misnomer when you think about what the agencies do and how they do it. When you think about the administrative process, when you think about the administrative state, so you think about securities regulation, sure, there's the statutes and there's rules and regulations. There's a whole lot of other ways in which the SEC, for example, administers the federal securities laws entirely outside the context of rules and regulations, sometimes without requiring a commission vote. A lot of things can be done at the level of the staff. Think about so-called no action letters. Those are staff actions as compared to commission level actions. And at a nuanced level, but an important level, there is a difference between when the staff does something at an agency versus when the commission votes. So that's one point. Second point, then Cary, a question for you with the windup, is reasoned decision-making, as has been noted earlier, is kind of the touchstone from an administrative law perspective. And one could also argue from a common sense perspective. It would be hard to argue that you would prefer your agencies to engage in not reasoned decision-making. Setting aside what reasoned decision-making does or doesn't require as a matter of the Administrative Procedure Act in terms of arbitrary capriciousness and all the rest, to zero in on the word reason for just one moment, an important point, and this was the thing that I also didn't fully appreciate till I got to the SEC, is people reason differently based on a whole host of things. So one way to think about reasoned decision-making is to think about it from the perspective of the rigor of the decision-making process. Sometimes, though, it is kind of cast in terms of does somebody agree or disagree with the outcome of your decision-making process. I point that out because you can have 5 folks, say, take a commission, who are very rigorous, very reasoned from that perspective, and yet come to very different conclusions as to what ought to be. And that point about what ought to be is a reflection of, again, something referred to earlier, human judgment entails a lot beyond, the more mechanical thought processes. That's a part of it, but there's a lot more that goes into a judgment, rendering a judgment about what the law ought to be or rules and regulations ought to be, particularly when it's through the lens of that's the government exercising power. And that's a really serious thing. So I add those points in terms of kind of the way agencies do what they do, even if at a high level, because I think it goes to the point around context and differences, and we talk as if these things are monolithic, and they're very heterogeneous, not homogeneous. So from that, with all of that and other things, Cary, you made the point or referred to the ways administrative law or administrative laws, that's going to stick with me, may need to change, may need to adapt, either because of the way government can use in a variety of different ways AI, and or because the government is working through ways in which it is going to govern AI and the use of AI in the marketplace. Are there certain aspects of, now I'm going to use the singular, if you will, administrative law that you think are particularly poised to go through a serious rethinking in light of what AI is ushering in, whether in the marketplace or in terms of government's own ability to use it?
We've got a lot out on the table, a lot in that comment and question and that lead up in a little back channel way. First, by picking up on this idea from, I guess, the ending of the last session, and Dan mentioned it too, are there some things that we wouldn't want to have AI do? And this really does get to your point. I think in answering these questions about what is the role for AI, it's always important to say, compared to what? Compared to what? And the status quo, folks, ain't perfect. In fact, it's sometimes not very good at all. I've been writing about AI, and I can just share that, and I sometimes will get some inquiries from folks I've never met or know at all. And I received a while ago a couple of letters from an incarcerated individual who was still waiting for a trial, and just sitting in jail, waiting. And he was writing to me to say, I would really, responding to a piece in which I was writing about the use of AI by judges in courtrooms, saying, I'd be open to that. I want some resolution. And I'm not for a moment in necessarily endorsing that we replace our Article 3 judiciary with AI robots. We're certainly a long, long way from that. But I mention it because I do think there is going to be, in the coming decade or decades, so much greater implementation of AI tools in so many walks of life where the public comes to expect a degree of efficiency, a degree of responsiveness, a degree of even fairness that algorithms can provide. I wouldn't want to say they will always provide, but responsible use of AI has the potential to make some improvements. Again, compared to what? And so we might well find that the public not only tolerates the use of AI by government agencies, but actually, in some instances, is demanding it because they don't want to wait around, or they want something that's fairer than what we see in the Social Security disability adjudicatory system, for example, where it's very well documented that there's wide variation in how those administrative judges can make their decisions. Sometimes in the same office, you'll have a judge that approves 90% of the disability applications and another judge that approves 10%. Is that fair? Whereas maybe a well-calibrated, well-validated, well-monitored algorithm could provide a greater degree of equity and efficiency. So as to what might change or need to change in administrative law, well, in some ways, perhaps much less than meets the eye, because one of the things that administrative law has as a central challenge to it is a concern about humans who go off and act in manners that are contrary to the public interest. And that may be unintentional, just because we're humans and we have implicit biases, or we have cognitive biases, or we have memory lapses, or we have various limitations to our cognitive processing that might be overcome by these AI tools, or it might be sometimes deliberate, but where we have maybe we have worries in administrative law about officials who are acting on reasons of favoritism, for example. And if a well-trained, well-validated, transparently created and also well-monitored algorithm might not be one that's going to play favorites even. So I think there may be a little less than we might think in our conventional principles of administrative law, worrying about humans and the principal agent problem that's created when humans take decisions. It's somewhat the same thing, and if compared to humans can do better, then maybe administrative law really will embrace it. Maybe this is even AI is in some sense, the culmination of what we've been looking for in administrative law. All that said, I do think there are really important best practices for the use of AI, for responsible AI. I don't think that, and this is another way that just talking about AI can be a little misleading, because somebody just taking an AI tool in a government agency and applying it to some decision-making sort of willy-nilly, I don't think that's what I'm talking about when I'm talking about responsible AI. So I think we are going to need to develop better principles for best practices that apply to the governmental use of AI, particularly in what the Europeans call high-risk areas, but we might even in our own due process canon of administrative law think about, those interests that are more fundamental to humans, where we need to make sure the government's being very careful and validating and using AI tools wisely. These tools can, when used for legal research, as Dan was talking about, they can sometimes hallucinate. If we're talking about these large language models now, they can sometimes hallucinate and make up cases that don't exist. That's not a good thing if we have government officials relying on hallucinated cases, for example. And one other interesting fact about this in the limitation of AI sphere, since this panel is all about AI post-Chevron, if you go on to ChatGPT, by the way, and do some legal research with it, it doesn't know that Chevron's been overruled because it was trained on data back before Chevron was overruled. So there are limitations to AI. I don't want to suggest for a moment that we should ignore those. No, we need to be very aware of those. But we also have to recognize that the human system we have is limited too, and be open to the possibility when technology could do better in certain circumstances when it's used responsibly than the current human system.
The point about Chevron and Loper Bright, Chevron being overturned, to generalize on that point, knowing what the data is, the inputs in terms of the training is really important, because then it can help one understand why you may get a particular outcome. But the other aspect of it too, which is perhaps a little more subtle, are views change. Policy preferences change. Values can shift. Those are broad contextual points as well. And so one could imagine a circumstance where you'd say, well, yes, given what the goals and the priorities and the objectives were and what the trade-offs were, because when it comes to regulating, legislating for that matter as well, I guess perhaps any decision, there are trade-offs. Some are more pronounced, some are more subtle, some are easier to detect. So I think that sort of understanding as to the inputs, and then you can contextualize the outputs, see how it aligns. But Dan, just to again respond to any and all of that, but I have one just sharper point on it if I could, because I'd be, not to put you on the spot, but I'm going to put you on the spot a little bit, even realizing maybe this is a little unfair. But you could imagine yourself as a commissioner. You could imagine yourself, and this question particularly as the general counsel of the commissions, as you have had the privilege to be, where the chair comes to you and says, "Hey Dan, there's all this really cool stuff going on when it comes to AI. I, the chair, want to use it to do this or use it to do that." Or, "Hey Dan, what are ways in which you think, or you as the agency general counsel, would be more or less comfortable taking into consideration some of the things that Cary was mentioning? How would you be thinking about it?" Realizing, again, context matters, and it's a they, not an it. How would you be thinking about it in terms of the things that would be top of mind to you in evaluating the conditions under which the uses for which you'd be comfortable from a GC's perspective, say, deploying AI within an agency, and then whatever else you'd like to respond to?
Great question. Couple things, just reacting. Generally, there's a lot of discussions that will go on between a chairman and his staff on let's say there's a controversial rulemaking, and there's a rulemaking record. You've received the public comments. You go to the chair's office. He's got a senior management there. What are we going to do? How do we take this in? And so there'll be probably a robust discussion within that office, and there won't be a transcript, and it's not going to be discoverable. And then the chair will give some direction. It'll get written up. And I think that's probably the way all agencies operate. That's my guess. The two that I've been in, that's how it's been, regardless of who's been the chair, I think, essentially. But then if you're introduced like an AI, and the chair would say, for example, well, let me put this to AI and get what it would do in the situation, or maybe draft up something that would raise a couple, as the GC, that would raise a couple of questions. Is that something that you would need to put in the administrative record? And is that if you're going external for some algorithm that's funneling in, so that your decision, the decision that would result from that would not be necessarily, or to what extent would it be the agency's decision, or to what extent are you relying on some external input? I'm sure that if somebody didn't like the rulemaking, they might bring a challenge and say, well, what was the input? Who had input into the, as Cary was saying, who had input into the model that you're using? Was that an industry-funded AI or what? So that would raise some additional questions about the integrity of the decisional process that I think you'd have to give the chair some good legal advice on.
Yeah, just to stick with you, Dan, because there's something else Cary said. Cary mentioned in terms of, and if I got this wrong, Cary, just tell me I got it wrong, but just mentioned kind of the culmination of what some conceptions were of regulatory bodies when they, came into being, in terms of how they, arguably what they have become is different than what they were envisioned to be, let's call it 90, 100 years or so ago. But when you think about the basic rationales that have been offered typically for having administrative agencies, in particular independent agencies, and what that contemplates in many recountings. And yes, we have the developments with Humphrey's executor and all the other administrative law developments in recent years. But you made the reference, Dan, to going back to the 30s and like when Humphrey's executor in 1935 was decided. How do you link? How does it factor into your thinking about administrative agencies? Set aside the independence, but just administrative agencies and how they do what they do, what AI may allow, may afford, and how that does or doesn't align with the typical suggestions as to why regulatory bodies, in fact, ought to exist in the first place in this thing called the administrative state. Dan?
I think that the question indicates what do we want, what is the agency doing? In some instances, the agency, if it's doing highway safety standards, how seatbelts should be designed, what type of crash they should be able to withstand, that's one type of thing. But one would think that would be more objective. But even there, which would be good for AI, but even there, really what agencies do a lot, they're allocating resources, they're allocating costs between different segments in the economy and the public. Who's going to bear the cost of this? How much risk are we going to take? Who bears those risks? So a lot of what the agency does is allocative rather than objective determination. These questions, even the seat question, which I just mentioned, that's ultimately a cost question. Like how much, better seat belts are going to cost automakers more. They're going to be added onto the cost of cars. Somebody's going to bear those costs. Maybe American well, it presumably applies to imports too, but it's how much risk and how much are we going to pay for our cars and for our safety? How many additional lives per year are we saved? Those are allocation issues depending on very human judgment. So I don't know. And this is what administrative agencies do. A lot of these administrative agency decisions are these allocative decisions. Industry groups, as I mentioned, come into Washington, say, oh, you can't do this. It's going to cost too much if you impose these costs. Ultimately, it's going to be the public that bears it. It's going to cost jobs. The banks aren't going to have enough money to lend. If you impose costs on Wall Street, it's going to hurt Main Street, et cetera, et cetera. So the essential job of the agency is to allocate costs and risks. I don't know that there's an algorithm ultimately that has the correct objective answer to that. It's ultimately, is it a human judgment on it rather than something you can stick in a mathematical formula?
I think there's a real possibility that our human systems aren't able to keep pace with the movement of the technology in making those kind of value choices, right? We have legislative processes that are supposed to democratically sort of set values, or even deliberative processes among the regulatory agencies. And they tend to move a lot slower. So this is something that I think it's a reality of the moment we're in. And as we're talking about the world of administrative agencies and AI, how does the value production process match up with the actual implementation process? Yeah, I do. I mean, just to give you some context, by the way, I've been working on a study to try to track the uses of AI at the federal government level, outside of the defense and security area, which is anybody's guess, I suppose. But I built a database so far of about 3,000 different use cases currently. Now, that was even before really the advent of this generative AI, where we don't know how many government workers are using it, whether authorized or not, for various tasks. But the agencies themselves have identified, whether as required by law through an annual inventory, or just have talked about or on their websites or the like, we've been able to kind of scrape and find about over 3,000 uses so far. And that just by way of comparison, back just a few years ago, the Administrative Conference of the United States commissioned a couple of studies, one by some researchers at Stanford and NYU, and they documented at that time about 150 different uses. So we're seeing definitely an increase in the use across federal agencies. What we're not seeing, though, by the way, is really among these 3,000 uses, ones where there's a lot of genuine human out of the loop, kind of replacing governmental decision makers, of true regulating by robot or adjudicating by algorithm. A lot of them are the biggest use area is in research and just understanding things that are happening in the industry or the like. Enforcement, allocative decisions, as you were talking about, big area, right? We've got limited auditors, inspectors. Where should we send them? But those are human auditors and human inspectors then that are still going and doing the actual work of reviewing whether somebody's in compliance. But it's moving fast. It's moving fast, and the question about where we as humans, whether we're going to be able to keep up with it, is in our social and governmental systems, I think is a very important and real question.
Of the 3,000-ish, are there some, at least thematically, that surprised you in terms of, like, wow, I wouldn't have expected that, or wouldn't have expected that now, or wow, that's an outlier, but that's really interesting. I can see the trend going in that direction. Anything that really got your attention?
Well, I think what maybe surprises me the most is how much room for opportunity is still being left exploited. That's probably the biggest thing. I mean, where do you see it? Like the Department of Energy reports a lot of use of machine learning in understanding, different things related to the management of the electricity grid, for example, and research on nuclear power. And we see, the National Weather Service using it in weather forecasting. But, I think there's so much, as much growth as there is over the past several years. I think the upward potential that's not yet being fulfilled is what's most striking, but maybe also not too surprising, because I do think to do this well, you need things in place. You need humans either in agencies or in contractors that are governed by a suitable contract. And I've written about what kind of parameters should be in government contracts for AI services. So you need that human capital. You also need technology systems. And one thing we know is that our government IT apparatus across the government tends to be woefully behind. And we're not really investing in these things as much as we could be. So I think it's an underinvestment story that's most surprising.
And so Dan, in the little time we have, we've talked a lot about how the government can use AI, and I think that's the whole point of the panel. But one of the things that's going to inform how the government can use it is going to be, I think, pressure on the government to use it. And that could be an efficiency story. It could be an equity story. It could be an overall effectiveness story, setting aside the degree to which humans continue to be part of it. And as AI systems become more advanced, that they can even help guide when you need more or less human involvement. So there's a lot of nuances and details that, as, again, the technology becomes more advanced, will allow for it not to be, are humans involved or not? There can be gradations to all of that in terms of when and how, et cetera. But part of it is in addition to that, part of it is that as the marketplace continue across the economy and across society, as the marketplace continues to use it, the government is not going to be able to sit back and say, well, it's going to take us 10 years to figure out how we're going to use it, because part of it's going to be need the tools in order to be more effective. And that's setting aside the policy judgments about what exactly to do, but just by way of leveraging the capability to fulfill whatever the policy judgment is. And those policy judgments may change as administrations come and go, et cetera, and as experience bears itself out. So you're in the private sector, you've been in the private sector, worn different hats, you've been in the government and public sector wearing different hats. As you think about the developments in the private sector, in business, in the marketplace, and what pressures are going to mount for the government to figure out how they are going to make greater use of AI as part of fulfilling their responsibilities. Any thoughts?
Oh, that's in the few moments remaining. That's another topic I feel very strongly about, having spent so many years in the government and now in the private sector. Definitely, absolutely agree on the use of AI. I just, as a lawyer, I see the incredible efficiencies and productivity gains you can have from it. But that only, again, as we've talked about, that only emphasizes the importance of having people who really understand its uses, its limitations, its potential uses, and the limitations of those potential uses, in charge of it and working with the humans and bringing the system in. Unfortunately, we're at a current period where there's more of an exodus, to put it mildly, than an inflow into government. I mean, right now, government is a disfavored investment in this country, and I think that's very unfortunate. So government needs individuals who are conversant in AI, younger generation, people who are now growing up with AI, senior people who are open to it and know how to use it. We need to encourage those people to come into government and bring these new tools in.
Cary?
Yeah, I think I agree completely with that. I think the understanding the limitations is really something we're seeing right now. I mean, over the last several months, we've watched as some folks from the private sector have gone into government and have tried to use large language models to, for example, decide which Veterans Administration or contracts for healthcare services should be canceled. And they there's a very interesting journalist who got a hold of the prompts that were being used by some Doge folks to figure out, well, which contract should we cancel in the Veterans Administration, and it is something that you know, I suppose younger people know how to use prompts. But what they don't understand is the trade-offs between, you know, and intricacies involved in managing large healthcare systems, for example, to meet patients' needs. And so we've got to marry. It's ironic that in order to use these technological tools to their maximum, that we've got to also be at our best game as humans as well. And not just come in, have some young folks come in and say, oh, I can just determine by asking this AI tool some questions about which VA contracts are munchable. That's what they were calling them. And, you know, I guess, you know, the bottom line is we've got to be at our best. As I said, in the human game, we do have to invest in this. We'll get out of it what we want. We also have to recognize that sometimes we can ask questions and get answers from some of these large language models that look and sound very confident and assured, but maybe no more informed than asking one's own teenager question in terms of how really informative they are. When it comes to, for example, evaluating whether a regulation should be remaining on the books or not, these tools are not, generally speaking, good at making causal judgments. So evaluating whether a regulation is or is not working is not something that, generally speaking, AI tools are going to answer for us. Now, they may be sometimes useful in estimating counterfactuals or projecting things, and that there may be a role for them, but we've got to know what that role is and not just simply assume that, oh, I've asked it a question, it's given me an answer and seems confident in the answer, and so therefore I should rely on it. That's deeply problematic. So AI has to be used responsibly, but if it is, there's a great deal of potential to overcome some of the limitations of our current human-driven systems in government.
So let me ask one, I think time for maybe one or one and a half final questions here before we take a break. There's a lot of guardrails, which I know is not a favorite word, leashes, which I know is a preferred characterization, metaphor, as you were saying. before you use the word responsible. Some folks talk about safety, governance. There's a long list of words kind of in that general spirit, and people have their preferred way of characterizing it. But thematically, they kind of go in the same direction. It's also the case, at least it strikes me, that an environment, and I'm using that word broadly, purposefully, that is conducive to, compatible with promoting innovation and AI's development and deployment is really, really important because there's so much potential in terms of the upside. And then the question is, which the question always is how do you make sure that you have an environment, broadly speaking, that is conducive, compatible with getting the benefits, and also managing in an appropriate way the risks that the judgments ought to be managed. And what that is to say in a long-winded way is that there's always some measure of trade-off. But Cary, to your point about as compared to what, there's also some measure of trade-off. And so there's that balanced, symmetric assessment as to how do you trade things off. And people of good faith will come to different judgments about what those trade-offs ought to be. And that's the essence of legislating. It's the essence of policymaking. It's the essence of rulemaking and regulating. And it's what in part makes it so interesting. But there's one common denominator, I think at least, which is wherever one would put themselves on the trade-off range, that trust ends up being an important piece of this. And trust can be a somewhat loosey-goosey word. And usually the word is used without much effort to define it, because if you try to define it, one can tie oneself up in knots. But I think we all have the intuitive sense, maybe that goes back to judgment and all that humans bring when they exercise judgment, as to what trust is. But there's also an instrumental element to trust, which is if there isn't trust in it, there will be fear, there will be unease, there will be resistance, there will be slow adoption, even of those use cases where there's real benefit to be had at a manageable, and the risk is able to be managed effectively. So with all that, I guess last question, from a trust perspective, in a minute or so for each of you, how important is trust, even if we don't try to define it here? And is there anything that you think is important to generating the kind of trust so that AI and its potential has real opportunity over the long term to meet its promise and isn't something that is met with too much resistance because of lack of trust and all that may entail? Dan, you first, and we can
great question. And I hate to end this on a down note, but we're in a country that doesn't trust any experts right now, and it's been a long strain in American intellectual thought and history. So certain level anti-intellectualism, but now more than ever, distrust in so-called experts. Why there would be any more trust in the experts who put together an AI system than in the experts themselves, I'm not confident that you could get there. I think we're in a very distrustful society, distrustful of authority. We're going actually in the wrong direction on that. As information is more, there's much more noise out there in the information system in the last 20 years than there's ever been. And the distrust, with more noise, the distrust is increasing. So I think it would be a real challenge to think that people would put trust in some AI system, that algorithm that would come up with the right answer when we distrust basically everybody who would be inputting into that system.
Cary, and then I'm going to ask Cary you a final question, which is more technical, but
okay.
This, and then one final, and then we'll call it.
Just three very quick points on trust. First of all, I think, and as I said before, as the public uses these AI tools in so many of their parts of their lives, in their private lives, I think they're going to come to expect it more of their government services and their interactions with government. Much like we saw with government websites, they weren't the lead, but boy, once you could start to do other things, buy books online, well, then why can't I, renew my driver's license online? So that's one thing. Trust is something that's fluid and it will evolve. A second thing is to just remember the adage of Ronald Reagan, and I think this really applies very much with AI. It's not just trust, but it's also verify. Trust, but verify. These tools can be very powerful and they can be beneficial, but only if they're verifiably so and validated and they're monitored on an ongoing basis. And the third, I guess, follows from that, and that is trust is something that you can have too little of, as I think Dan was mentioning, but you can also have too much of. And so I think, like with a lot of other things in life, the real question and challenge is finding the optimal level of trust in these tools. And that will vary probably from use case to use case, from technology to technology. But if we, do seek to try to come up with processes for verifying, validating, monitoring, having transparency around them, those are ways that we maybe will get closer to that ongoing search for optimal trust.
All right. So having gone big picture to end, although I think a foundational point in all of this, I'm going to end with one final question for Cary. Is a great question from the audience, in some sense takes us back to the origins and the initial prompt for the panel in terms of deference, mixing deference and Chevron there in my combination of the two words there. There are more types of deference than Chevron deference, even when we had Chevron deference, one of which is Skidmore. And so the question that came in from the audience is, what, if any, are the impacts, when you think about it from the perspective of expertise, et cetera, of AI in terms of how to think about Skidmore deference, if any? So if you can maybe take, Cary, 30 seconds on Skidmore, and then if you happen to have any thoughts about whether the advent of AI and the ways we've been talking about or other ways might have implications in terms of how that body of jurisprudence evolves.
We only have 30 seconds.
Well, I'll give you 30 seconds to explain Skidmore, and I'll give you a minute and a half to explain implications.
Well, I mean, the big difference between Chevron deference and Skidmore deference, and both of these are, by the way, are deference in terms of thinking about how agencies have construed the statutes that they operate under, is Chevron deference, which one would only, under the old conceptualization, get to after a series of steps that would be if the agency's construing an ambiguous statute and it doing so reasonably, then courts were obligated under Chevron to defer to the agency, because the idea was that Congress has either explicitly or implicitly delegated the authority to the agency to decide what that ambiguous statute means. Skidmore deference, which is always there in the backdrop, even when Chevron deference didn't apply, was simply that, courts, you can be persuaded by what the agency says a statute means. And, AI tools may be helpful in making that persuasive case, perhaps, if to the extent that they might be helpful for the agencies to build records and what words mean or were intended to mean around the time, say, a statute was adopted. Perhaps we haven't really, I think, fully exploited or seen the full potential, probably, of what AI might be doing in the realm of statutory interpretation writ large. So I will say the thing about the overturning of Chevron and the Loper-Bright decision that the court made, it's not clear to me that Chevron really has died. It's just maybe changed some of the labels and the language around it, because if one reads the Loper-Bright decision, the court still says that agencies have delegated authority. Sometimes that's explicit. Sometimes that's just authority to, what the court says, fill up the gaps or fill in the details. Sometimes it's authority that's implicit because of flexible language, like words like appropriate and reasonable are two that they offer as examples. And in those cases, which seem like whether it's explicit, filling up the details, or flexible language, give you a lot of what Chevron always had. Courts then are supposed to, in fact, like 3 sentences after, in the Loper-Bright decision, 3 sentences after the court says Chevron is overruled, it then says courts must respect the delegations given to agencies. So we may be no longer calling things deference, but we may be thinking about them as delegations. And so in this post-Chevron world, I don't know how much things will change. That's going to be something that we'll have to see playing out for some time, probably. I do know that courts are citing Loper-Bright up the wazoo. They're citing it more than Chevron, but not necessarily relying on it. I don't think they're just. It's a nice decision that judges like to cite because it says, judges, you should decide cases, and of course they should.
Well, it's always great to talk to Dan Yu, Cary Yu. Chance to chat with you together has been a great opportunity for me. So if you join me in thanking Dan and Cary.